What we wanted to do was to unpack the argument, and so we've assembled a very distinguished panel. Let me introduce them going across the table. We have David Vines, Professor of Economics at the University of Oxford, who's just told me he has been up half the night liaising with the IMF in terms of how to fix Europe. I'm sure he's pretty tired this morning. But
you're not alone.
Beside him is Greg Medcraft, who you all know is the chairman of the Australian Securities and Investments Commission. And then we have John Colvin, the Chief Executive Officer of the Australian Institute of Company Directors, Professor Seamus Miller from the Centre for Applied Philosophy and Public Ethics, and at the end of the table we have John Morgan, who you all know, who is a partner here at Allens, and I want to thank Allens for its hospitality in allowing us to use these fabulous premises this morning. What I've asked each of the panelists to do is to give a 5-minute initial response to Professor Stout's lecture, and then we'll open it up to interactive questions from the floor. So if I can begin, I suppose, well, let's begin at the level of the firm and the director, John Colvin.
Right, I thought I might have had a bit of a briefer introduction, but I'll go. I read Professor Stout's paper, and I thought it was a very, very good paper. Lots of really interesting aspects to it, and lots of things which resonate, I think, in the day-to-day operations of directors. So, given that I'm in Allens, I'll be quite circumspect in putting out any law, but I understand from my studies of law that in Australia the duties of a director are to the corporation itself. And in a lot of the discussions and cases and the way we teach, if you have a duty to the corporation, that doesn't necessarily encompass a unilateral economic view of shareholder value only. In fact, the discussions and the cases talk about variously the sort of things really that Professor's been talking about, but and a director really has to, one of the hardest parts of being a director is dealing with all these competing issues with staff, consumers, politicians, political issues, and shareholders. However, the fundamental, I guess, thing in all of that is, I think Don Argus put it well, although he was criticised in an article recently, because I didn't talk about his premise to get there, is one of the issues for a director and executive team is to be given a pot of money from shareholders, bondholders, etc., and then do their best to increase that over time. And the issue really is, I think, as you've adequately and very eloquently put, increase that over time. That means that you might have to take hits in the short term. That means that you might have to make investment decisions or make decisions which don't actually help the quarterly figures. But in the long term, and the view that certainly we espouse, is directors are there to look after and steward the company over a long period of time for the benefit of long-term shareholders and long-term investors, and also the community itself and the employees and other stakeholders. Now, there's lots of interesting law about that, which people far more eloquent than me and better informed can probably talk about that. But that seems to be the generally accepted view in Australia. So I'm not sure whether Milton Friedman, although I did economics for about 5 years and I learnt there were cycles, I don't think, and I haven't been able to pick any of them, by the way, but I don't think Milton Friedman's view in Australia is as pronounced, you know, in the Australian context. I think it's far more probably to where you would go. Then, but it does raise a number of other issues, which is we had a period where, a long period in the 50s and 60s, where shareholding was pretty diverse, and management didn't really have to concern themselves too much, or to the extent that they do now, about dealing with individual shareholders. And then since in Australia superannuation and fund managers, etc., that coalition, or that bringing together of shareholder groups, as you say, has brought in, I think, pressures which are far more intense now on directors about dealing certainly with shareholders. The problem there for directors, though, gets a bit more woolly, which is which shareholders are you meant to be dealing with? And some of you may have seen the report we put out recently on institutional shareholding and about working out, well, so who does a director go and deal with in the event that they have an issue they want to discuss with shareholders? One of the examples in Australia, because we're a bit obsessed about it, is executive remuneration. So who do the directors go and talk about to get the view of the shareholders, given that we have a system which I don't think anyone else in the world has, where we have the 2 strikes legislation. You've probably heard about that, where if you get more than 25% vote against in 2 meetings, then you have to then hold a meeting for the whole board to be spilled. So the question is, who do the directors go and talk to about getting this? And you've got a disaggregation of people with shares. Now, I was told, and I don't know whether this is true, so somebody in the audience probably knows this, that for every share in a major listed company, there's about 10 contracts out on various shares. So there's a put option, there's another option, there's a loan for a vote, there's a sale of a this, and so you've got whole lots of disaggregation of a particular vote. Then you have disaggregation of what are the shareholders, who are they, and that gets down to hedge fund operators, long-term mums and dads, small superannuation funds or self-managed superannuation funds, long-term investors. And I understand from a speech that David Gonski gave, who's the chairman of the ASX, that the average holding of a share in Australia at the moment is 20 minutes. So this is posing, I think, quite some challenges for directors about who, where they have to talk to shareholders, which ones do they talk to. Then you also have the disaggregation of those who advise on voting behaviour, those who then decide, and then those who have the ultimate say in that. And that's an area where we have suggested that there needs to be more work from directors, institutions, etc., to try and make sure there's better communication in this area. So that's, I guess, one of the areas. The other area I think that you raised at the very beginning, which I think we shouldn't lose sight of, is that I think it was described as the greatest invention, one of the greatest inventions ever, the limited liability company. Our standard of living in Australia and elsewhere in the world depends pretty heavily on, quite frankly, that invention. And I think it was the statement was, and I can't remember it exactly, it's a greater invention than even the electric light and lots of other things. Because if you look at the tax revenue in Australia, and I don't know what it is in the United States, but if you look at the tax revenue in Australia, that coming from corporations, basically if that goes, so does the economy. I say that, but you rarely hear that said by a lot of other people, because it's not necessarily a view which people want to hear. But if you take away PAYE tax, corporate tax, GST and a few others, there's not a hell of a lot left. So the value of corporate life and the 2.1 million directors in Australia, which is not just in the listed space, but in the not-for-profits, the charities, etc., is a fundamental issue for us as directors, as organisations, fundamental issue for the whole of society. So I think I might stop there, because I could go on too long about various other things.
Okay. John, thanks very much. John Morgan.
Well, I suppose I can speak as a lawyer. I think John has outlined what I think is the primary and normal way of framing the duty of directors in Australia. That is, it's a duty to the company, and the courts are saying that consistently now. But then the question of other interests, and clearly directors are able to take into account other interests, but in terms of what interests must they take into account, it's normally looked at in terms of the requirement to take into account creditor interests in impending insolvency. But I think if we actually look at the framework of our law, that's not right. And I think that examination leads to another way of considering the role of directors in our community. And that is because our law contains a number of obligations. The type of obligation which may be similar to the traffic offence of not stopping at a red light. And those obligations are imposed upon companies. In some cases, they're imposed directly on directors. And I think we saw in Centro recently the obligation on the director to sign the declaration relating to the accounts. It really doesn't involve a duty to the company, it's an obligation on the director. And those obligations are formed by government, and I'm not sure that they're really thought about in a whole of society or whole of economy point of view. They tend to be generated by particular objectives or interests or the like. Environmental laws is a very good example. But if we step back and now look at the position of directors, more often than not, what we're seeing in the courts is directors being held liable in various ways in respect of these obligations, and the duty provisions are in part generating that liability. So we see cases of directors being liable directly for a breach of an obligation imposed on them, and we find that in some laws. We find directors being liable because they're knowingly involved in a breach of obligation by the company, the accessorial liability. And we also see more often directors being liable for permitting or allowing a company to breach an obligation. And that permission or allowance is framed as a breach of their duty to the company. So in one way, from a lawyer's perspective, directors are sitting in a situation where they've got to look at where they may be liable. And the question then arises as to whether or not the setting of all those obligations are properly framed, having regard to where we really want companies to go and what we want them to do and how they work within our economic system. And I'm not sure that thinking process is actually there at the moment. I think we have a whole lot of disparate things, and that leads in turn to the problem that directors face in dealing with these matters. So I think that in a way, the reality of directors is they're not really faced with shareholder primacy. What they're faced is with a large mix of obligations in the context of their duties. And I think that in that context, the director's role is quite difficult. And I think I agree with John. I mean, so my conversation with directors, I think directors do get the message. They do understand they've got to have regard to other interests. And certainly speaking to some senior directors, they are really focused on long-term sustainable value. And given that superannuation investment now in Australia is very large in our corporate community, that must be one of the prime objectives of those who are ultimately the economic beneficiaries of shares. And they certainly don't own them, but that is the members of super funds. And one wonders whether the issue about shareholders is become so difficult because of the fact they're sort of this ephemeral moving group who you can never know from day to day who they might be. And in many circumstances, the people who vote are not the people who really have the economic interests that lie behind the shares. So that's my perception as a lawyer as to where we are at the moment.
Okay, John, thanks very much. Greg.
Yeah, look, thanks, Professor Stout, for your work today. I think it was very thought-provoking. I'll pass it back to my commission. I think this discussion is relevant to ASIC's strategic priorities. I think that in particular the first outcome, which is confident, informed investors and financial consumers, it's very relevant, particularly in the areas of education and gatekeepers. Talk about that. And also our second outcome, which is fair and efficient financial markets, because the two interact. But I think here there's really, I see three relevant issues. One, corporate accountability. Two, shareholder activism. And three, director responsibility. In terms of corporate accountability, I think as Professor Stout said, the law does not prescribe the directors must do whatever raises the share price. The requirement is it's got to be in the best interest of the corporation. I think now we see a number of corporations now speak not of stakeholders in addition to shareholders, so I think you are seeing a change in society. You also even hear about shareholders talking about a company's social licence to operate. And I think we see now around the world, the emergence of reporting in respect of environmental and social reporting is, I think, a very significant trend, and I think that. So I think I think the law often, you see an expectation gap emerging, and I think we're seeing, I think the community is actually focusing a lot more on that. I think also, while the focus maximising short-term share price can produce adverse outcomes, I actually think companies should focus on maximising long-term shareholder value, because I think that generally results in an alignment in terms of, basically all stakeholders benefiting. And just in terms of the comment, I think at the end of the day, having been in investment banking, I think the market focuses the market actually adjusts in terms of things. The PE ratio, I think, is something very important, because generally, as we all know, that if you can achieve an increase in earnings, but in fact, if the market actually thinks that those earnings are not sustainable, it adjusts your PE ratio down. So if you're looking at long-term value, most good companies look at their PE ratio, and I think what we saw in banking is that if in fact the market felt that your earnings were not sustainable, or your model wasn't sustainable, you might be earning high returns, but your PE ratio would decline. So, I think that there is a very important, I think you've got to look at the quality and sustainability of those earnings. So, I think corporate accountability is very important. Companies and their directors are important gatekeepers. In terms of shareholder activism, I note many of Australian institutional investors are active investors. Unlike the United States, Australian institutional investors are not required by law to vote their shares. But since the 90s, and the work, I think, of institutions like the Financial Services Council, fund managers and superannuation funds have developed a culture of taking voting seriously. In fact, I think to be a member of the FSC, I think you have to agree to vote your shares at meetings. So I think there is a culture of being active, and I think it's important that they are active, because to me, institutional investors are also gatekeepers, because they manage the public's money, they manage people's money. So I think it's very important they actually maintain their role in terms of making sure they actually have proper vigilance in terms of what corporations are actually doing. So I think it's actually quite important in terms of them as gatekeepers. And another aspect of activism, I think, is the corporate governance advisors. I think, frankly, they're a good phenomena. But I think what's important with proxy advisors, I think it would be good if perhaps they're clearer about, in terms of being transparent about the methodologies they use, about how they train their staff, and also perhaps their accessibility. But on the other hand, I think it's important for corporations to explain how they use proxy advisors, and when they're deciding how to vote, how they actually use the advice they've got. So, and finally, in terms of director responsibility, Centro, I'm happy you mentioned Centro. I think, frankly, Centro, I think, reconfirmed the importance of directors meeting their responsibilities. And as I've said before, three things that directors should take away from Centro is scepticism, that basically they should challenge constructively what is presented to them by management. Secondly, accounting knowledge. If they don't understand the financial statements, which are finance is the lifeblood of a company, then they perhaps should get some training. And thirdly, accountability and control. At the end of the day, the directors are those that are responsible for the company, and they need to make sure that that they have in place the right systems of accountability and control. So, as I said before, I think today's discussion is very relevant to ASIC in terms of our strategic framework, and I like to have a debate. But I think largely, I think there's a lot of sympathy with many of the points you're making, actually, Professor Stout.
Okay, thank you very much. This clearly has an impact on the academy as well. So we have David Vines representing the economics profession, and Seamus Miller, philosophy and applied ethics. Let's begin with David.
Thank you very much for organising this meeting, and thank you, Lynn, for writing such a good book. It's a remarkably good book in that it's a very good read, and it's also underpinned by very firm analysis. And it's not often that you find things that are both of those. And I have to say that the other book, which Lynn referred to, Cultivating Conscience, is a pleasure in a similar way. I want to say 4 things. That this book and your talk this morning describes, I think, the way things are. Secondly, I want to talk briefly about why. Thirdly, I want to just describe what a challenge it is to fix. And fourthly, a hint on how. And that's a lot in 5 minutes, I'll be quick. First of all, things are like this. The Qantas story is a very good one. So is Southern Cross Healthcare in the UK. Both targeted by hedge funds whose task was to do a highly leveraged buyout, take out the capital, leave these as very leveraged firms, subject to the risk of difficulty. Of course, all the Qantas planes would have been owned by someone in Singapore, and we would have been walking to Sydney from Melbourne. Now, in the end, there would have been somebody else run the planes. That's externalising costs. Secondly, Southern Cross Healthcare, highly leveraged. There was a scandal in that along the way, some third-rate, second-tier managers, 6 of them, each got 2 million payoffs to organise this. But the real issue was that 30,000 old people in Britain were terrified in not knowing whether their healthcare was going to close, their accommodation was going to close next week. Why? You have to realise that both the deal for Qantas and Southern Cross, they didn't turn these firms into trash, otherwise the hedge fund couldn't have got out. They turned them into what risk-neutral people would think is a pretty good deal. And you know, if it goes down, well, we're diversified. And it's not very good to tell the pensioners, sorry, diversification means that actually people don't care much. That's externalising costs. Now, this is one very specific way of reading Lynn's message. So this stuff matters. Second, why are we here? I think it goes much further back than Milton Friedman. I was Adam Smith Professor of Economics in Glasgow before I moved to Oxford. This is Adam Smith's invisible hand. What we teach our students is that markets are efficient. That's the first basic theorem of welfare economics. And then we do in the course all that important stuff about monopoly, externalities, moral hazard, adverse selection. And that's what you're about, fixing that stuff. And all our students go out thinking that that's how the world is. Now, where's the firm in that stuff that I teach my students? Well, it's an agent just like the individuals. The individuals maximise utility and the firms maximise profits. And what's more, all these models have the profit maximisation feeding stuff to the individuals so that globally this is a welfare maximum, apart from all these things which we teach our students. This is why we're there is Adam Smith's invisible hand. And my profession told everyone that that was cool and efficient markets theory was right, and let's get on with it. I've been doing work on financial reform. This is a much bigger issue than finance, but it pins straight into the financial reforms. So we're guilty is why we're there. Thirdly, what to do? Well, it's difficult, and I tell you why. We talked to Lynn about this last night at dinner. It's difficult for the following reason. Nick Morris in the audience and I are leading a group, a wonderful interdisciplinary group of philosophers, historians, economists, whatever, lots of people, thinking about the duty of care in finance, what to do about the ethics of financial reform. And what we've identified is that the employees of financial firm may act, have acted in ways which is not in the interests of their customers. They do churn, they do high remuneration for themselves, they have a fantastically good skill at devising tail risk assets, which mainly pay off and yield them fees 2 and 20, but just sometimes tank and take out everything that the investors own, and just guess what? They just don't get their 2 and 20 that year. So the conclusions, is as in these firms, the employees may exploit the customers and clients. Now, guess what? Until reading Lynn's book, I thought, well, you know, what I got taught in graduate school was that shareholders fixed that. The shareholders are the guys who stop this stupid behaviour being carried out by the managers. And in some sense, that still is underpinning some of Nick and my thinking. And that thinking's run aground after reading Lynn's book. So final remark, what to do, and it echoes quite a bit about what Lynn said and the other three people have said. I think that this will only happen when two things are at the centre of understanding. First of all, that the managers and their employees become professionalised. That hasn't been part of any of the discussion today, except very obliquely. Doctors are professionalised, lawyers in a way are, accountants, architects can get thrown out of the profession for acting in an unprofessional manner. And secondly, that it should be the task of corporate governance to make the firms a place where professional employees can flourish. Now, I would agree with what has been said earlier, but notice that that wasn't described as one of the duties of directors. And I think it's extremely important that that becomes one of the duty of directors. Now we go back to Southern Cross and Qantas. What was wrong with that? Was it that the boards were just short-sighted? Well, no. They got out on Southern Cross. They sold it all right. The hedge fund made a lot of money. So Lynn says, well, they should have had an obligation to keeping those care firms going. This wasn't just an operation for a hedge fund. This was old age care. Now, keeping old age care going is an economic objective with long-term aspect. I think one might need to go one stage further and say our objective, Qantas too, is to make Southern Cross Care a place in which people who work feel proud of being professionals who do old age care. And that's one stage further than making sure that Southern Cross survives as an old age care organisation. And so I think that it must be the task of boards of governors, I'm aware I'm in a legal building and must is a strong word. I believe it would be an advantage to work in this direction and to have the law help us work in this direction, where it becomes one of the obligations of boards of directors that to help their companies be companies of this kind. Thanks.
Seamus.
Yeah, well, let me first thank Lynn for a very interesting and provocative, perhaps in some context, lecture, and also thank Justin for organising this meeting. Justin's asked me to speak about purpose, and specifically the purpose of corporations. And as a philosopher, and perhaps particularly in the light of what's happening in Europe and Greece, I thought I'd invoke Aristotle at this point, since he's the philosopher par excellence who's focused on purpose. According to Aristotle, you can't really work out what you ought to do. You can't really work out what an organisation's structure ought to be, what its management policies ought to be, or anything much else until you figure out what its purpose is. That is, what is the good that organisation or the market or whatever it else is in question has been established to achieve. So the question resolves itself for Aristotle in relation to corporations is, what is the purpose of corporations? Why do we have them? What is the good that they produce? And the same set of questions pertains to any particular occupation, lawyers, auditors, academics, or any other group. I agree with Lynn Stout that simply ascribing as the primary or sole purpose shareholder value for corporations is not correct, and in fact it seems to me to confuse institutional means with institutional ends. The ultimate ends of corporations aren't to reward shareholders, they're not to reward managers, they're not to provide salaries to the people who work in those corporations. Those are all means to an end. Those rewards are simply the means by which we try to ensure
that the corporation actually achieves its purposes. They may be the specific motives of shareholders, of people who are employed and so on, but that's not the purpose of the entity. To figure out what the purpose of the entity is, we've got to, I think, revert to Adam Smith at this point, another important philosopher. And essentially what Smith would say, I think, is that the purpose of having a director, the purpose of having a lawyer, the purpose of an auditor, the purpose of an employee and so on, has to be seen in the context of what the purpose of the organisation is. What does the organisation exist to do? And the organisation itself needs to be thought in terms of the market to which it is a participating contributor. And essentially what he would have suggested, I think, is that if we're talking about a car market, the purpose is to produce an adequate supply of high-quality cars at minimum cost. The purpose of a capital market is to produce an adequate supply of minimally priced capital. That's the raison d'etre. That's the reason we have these things. And if we work back from that hypothesis about the purpose of the market, we can see what the purpose of a particular corporation might be, and we can see what the purpose of a particular role in such a corporation might be. So if we move then to corporations in particular, they're a specific organisational form. They have a specific, they're not the same as partnerships, they're not the same as private firms. So we've got to ask ourselves, why have corporations, why have these particular kinds of organisation, for example, that have limited liability? And I take it that part of the answer is that they serve general purposes according to the market, as Smith would have us believe. That is, that these organisations compete at a marketplace and they maximise quality and minimise cost and provide an adequate supply of cars, capital, or whatever else it is that we want that market to produce. However, the specific form, that specific organisational form that the corporation takes is presumably itself to be justified, and I take it that part of the justification, at least historically, is that when it came to fairly large-scale long-term projects which needed a large amount of capital, the way to achieve that was in fact to have limited liability companies, shareholders and whatnot. So if that's the particular purpose of that organisational form, the corporation, then of course we would need to ask ourselves whether or not it's achieving its purpose, whether or not it's fit for purpose, particularly in the context of what Lynn Stout has been telling us, that actually these beasts that we've produced to serve long-term, large-scale projects are actually fixated with short-term shareholder value. Because if that's the case, then they're not actually fit for purpose. The final point I'd make here is that in relation to certain sorts of organisational activities and professional activities, it may be that these stand in some tension with the market hypothesis to start off with, not simply with corporations per se, but with the market model per se. And I'm thinking here of two examples. One recent example in news is news corporations. Now the purpose of news corporations is actually to function as part of the, I would suggest, as part of the fourth estate. That is, they're there to provide important information and forums for people to provide comment in relation to the smooth functioning of a liberal democracy. And if they're not achieving that purpose, then there's a problem. And clearly there is a problem with news corporations, with News Corporation in particular in the UK. And so another example might be with incorporated legal practices. We need to understand what lawyers are there for and what legal firms are there to achieve, and whether or not incorporated legal practices is a good idea depends on whether or not it's a good way of achieving those purposes. Maybe it is, maybe it isn't. Certainly there looks to be a need to restructure those kinds of organisations in that context, and I take it that things like establishing the position of a solicitor director, for example, is one way of trying to achieve that. So the final point I'd make is this, that we need to think in terms of the larger purposes. This is not actually about, it's about specific purposes for specific markets and specific forms of organisation. It's not actually about, by the way, a corporate social responsibility or stakeholder theory, which is far too amorphous, it seems to me, to achieve these purposes. Thanks.
Chairman, thank you very much. Lynn, would you like to comment on any of those comments before we open to the floor?
I would, of course, like to comment on all of them, but I also want to hear from the folks who were kind enough to attend this morning, so I'll try and keep it brief. Wonderful comments. Basically, I agree with 85% of what I've heard, so I'm just going to touch on a few things. It's very interesting to me, and I do see this pattern in the United States as well. Real directors and real corporate lawyers, if you press them, will say, you know, the duties are owed to the firm. They're not owed to shareholders per se. So at least in the United States, the pressure for maximizing shareholder value is coming, actually, it's almost external to the board. And so it's coming from, for example, in the United States, we did something dreadful in 1993. Our Congress changed the tax laws so that corporations could only deduct executive salaries over $1 million if they were tied to objective performance metrics. This was just a dreadful decision and in many ways responsible for much of what we're suffering today. Done with the best of intentions, the idea was to incentivize executives to do a better job for shareholders. Clearly didn't work out the way we had intended. Another source of external pressure, in the UK at least, is the takeovers panel and their takeovers rules. So the problem is, as a director, you can't think for the long term if you've got a bidder showing up saying, oh, guess what, we're going to offer a premium price to your shareholders, and then after your shareholders sell out, we're going to bust up the firm. So there are these external pressures on directors that I think we have to take very significantly. The other thing I think that is absolutely essential, I meant to get to it, but I got so carried away. As you can tell, I get very enthusiastic about these topics. I just find it interesting. And I also get enthusiastic because, to me, it's fixable. You know, we're our own worst enemy. If we can come up with the right sorts of laws and the right sorts of rules, we can actually make things better. I get excited about that in a rather Adam Smith sort of way. But our next job is to do what Greg Metcalf is inviting us to do, which is to unpack this notion of the shareholder and understand that different shareholders have different interests. And I think what's been missed there, and what I try to highlight in the book, is the problem is different investors are not playing on a level playing field. In particular, diversified investors, by virtue of their sheer diversification, tend not to get involved in corporate governance and tend not to be in a position to protect themselves from the problem of external costs. It's the undiversified investors, the hedge funds in particular, that have undue influence. They're punching above their weight, seriously. And it's also the hedge funds that have these short-term interests. To a hedge fund, if you hang on to something for 3 years, that's a long-term investment, right? So one of the job that Greg has to face is how can you restructure the playing field so that the diversified investors, the long-term investors, the pro-social investors, the moms and pops are in a position to catch the ear of the directors in the same way that a non-diversified, short-term, deeply involved activist hedge fund can. And finally, on the purpose of the corporation, I'll actually write it even more broadly than Seamus does. It seems to me we have to understand that business is subsidized by society. Business can't exist without public subsidization. I mean, you know, the illegal drug dealers, they have to run a business without public subsidization. But legal businesses, they get subsidized because the public pays to enforce their contracts. They get subsidized because they're given the great gift of limited liability. Business only exists because the public wants it to exist and subsidizes it, which seems to me that at the end of the day, business has to have a public purpose. And the public purpose is, I would actually put it, to generate a surplus. A business that is not generating a surplus, is not creating wealth for society, is not a business that deserves public subsidy. Now, once you're generating wealth, I become, as a good economist, somewhat more indifferent perhaps than I should be to who gets the surplus. You can give it to the shareholders, you can give it to the employees, you can give it to the creditors. You know, my view is that's above my pay grade. But what I am concerned about is that when the pursuit of shareholder value leads business to stop generating a surplus. And when I see the pursuit of shareholder value essentially leading shareholders themselves to push for blowing up the business in the interest of short-term profit, then I think business isn't doing what we collectively want it to do. And it's time to stop subsidizing it. So I'm going to quit right there because, you know, I think we've got some really broad topics here, and I'm sure there are people in the room who have some opinions.
Yeah, look, I actually agree with you. But I think the issue for companies is that I think these days, if you are being attacked by a hedge fund, then I think companies need to be more proactive about putting out their long-term message. And I think companies have got to think about using multi-channel communication. They've got to think about using new media. You've got now with Twitter and with Facebook, you've actually got great channels where you can actually really push out your message and get your message across. It's not just on the exchange. So I do think they've got to think about being more proactive in putting out their message where they are being challenged. The second thing, I want to make the point is, I completely agree on ethics. I frankly think we've got to do a lot more work in schools and elsewhere in ethics, frankly. And I often say that, self-regulation is, most importantly, is going beyond the law, but particularly thinking about thinking about ethics and doing the right thing. So I completely, I think if we had more ethics, I think you would actually probably need a lot more, less intervention, frankly.
And I can't agree more, and actually I'll shamelessly plug my other book. It's called Cultivating Conscience, How Good Laws Make Good People. And the basic theme is that, there's a tendency when things go wrong to think it's a matter of good apples and bad apples, good people and bad people, and that's not the way it works at all. Ethics are something you can create, but they have to be supported by the institution. And so I think one of the great challenges, if you want a thriving institution, is to figure out how to structure them so that they support ethics instead of undermining them.
I agree.
And what specific role then should ASIC as a regulator play to ensure that the ethical framework is improved?
Well, look, for example, recently, I chaired the advisory panel on standards and ethics for financial advisors. And I think there, we've come up with a recommendation to the government that I think starts to address how you embed ethics in the financial advice profession, for example. So, because let's face it, as I said, I think at the end of the day, if it goes beyond, if you think about it, it's about trust and confidence of investors. And if investors and consumers can feel that the parties they're dealing with will do the right thing, it's not about just strictly complying with the letter of the law, but it's about what's behind it. I think that, as I say, I think that's a good thing for us as a regulator, because it actually means that we actually leverage well what we're doing, because if people are doing the right thing, then there's probably less for us to do, frankly. So I think it's a very important tool. Yeah.
John, do you have a comment?
Just 2 points. One is, I'd like to hear a discussion about what happens when you have a society which makes 702, I think it is currently, state laws making directors personally liable. And when you have a system which makes directors criminally liable for what I'd call just being a director. I mean, that's called, accessorial liable, what have you. I mean, what does that do to the long-term willingness of directors to take on positions? And secondly, what does that do to talented, experienced people who may have many other options? And we're getting surveys from our own members on this area, which is being a director, the risk reward perhaps, despite how ethical you may be and despite how good you might be, is becoming an area which is not as attractive as it should be for the rest of society. So I think in Australia we have a sort of a different model, which is the limited liability company is becoming unlimited for directors, but maybe for nobody else. And I think that's a big issue in Australia. And the other aspect, I think, which is really important, is that you train people, as you do in law, in ethics and very nature of being trained in law is part of that. But the very nature of being a director and undertaking the courses, for example, that we run, are basically around those issues. Who are you there for? What are you trying to do? What are the conflicts of interest? And why ethical behaviour is so important. So I think, there are two themes which, I'd really quite like to hear anyone else.